continuing to meddle in city business. They've done that on a whole host, not just public safety, but this has been designed to withstand that.
That this bill would ban weapons that are in common use in the United States today.
Restraining order said no. The court has made clear that there has to be a precise law if you're going to restrict the Second Amendment.
When attached to a firearm, does not convert that weapon to be fired from the shoulder.
Here's the amount of gun violence that has happened. I think we're reaching a tipping point where we're about to hit desensitization to gun violence.
Also, this bill was written with constitutionality in mind, so I definitely had a good feeling.
The ADF has now virtually stated that they intend to take this issue back to the Supreme Court for a full merits review on its constitutionality, which is a key development in the Vanderstock frames and receivers case. Second Amendment dispute. Next fall, the Supreme Court will hear oral arguments in a significant armed rights issue that questions the validity of a federal law prohibiting those covered by domestic crime restraining orders from possessing arms. Following the ban's invalidation by a federal appeals court earlier this year, the Biden administration requested the justices to provide their opinions, and on Friday, they granted it. In a set of orders issued by the justices, it was announced that they had granted review in the case of United States versus Rahimi. On Thursday, June 22nd, the justices convened their final regularly scheduled conference prior to their summer holiday. On Monday, June 26th, the justices released the decisions from that meeting. However, after releasing all of their rulings for the term, the justices customarily convene another conference, dubbed the Cleanup Conference, to address any petitions for review that have been put on hold while they wait to hear relevant cases on the merits.
Continuing to meddle in city business. They've done that on a whole host, not just public safety, but this has been designed to withstand that.
Thank you, Mr. Chairman. Real quick, I find it interesting that my colleagues have no problem with the ATF going outside its boundaries.
Money gun owners and people who want to buy a gun might have questions about how these new laws affect them.
That this bill would ban weapons that are in common use in the United States today.
Is the goal of the ATF to go after and criminalize law-abiding Americans?
Individuals' right to keep and bear arms. Well, what does that mean, right?
The judges granted review in 7 new cases on Friday, including Rahimi, continuing their trend of adding matters to their docket for the next term. In the 2019 argument in a parking lot, Texas man Zaki Rahimi slammed his girlfriend to the ground and dragged her back to his car, hitting her head on the dashboard. Rahimi is the one challenging the armed possession prohibition in court. Rahimi threatened to slay the victim if she told anybody about the attack during a phone contact they had after it happened. A few months later, Rahimi was subject to a domestic crime restraining order issued by a Texas state court. Rahimi was also prohibited from owning an arm under the order, and he was advised that doing so may result in federal criminal arrest while it was in force. While the order remained in place, Rahimi was a suspect in several slayings that occurred around a year later. Along with a copy of the restraining order, police officers discovered a pistol, a rifle, and ammo when they searched his residence in response to a warrant. Rahimi faced charges for breaking the federal law prohibiting anyone covered by a domestic crime restraining order from owning a handgun. After entering a guilty plea, he was given a sentence of somewhat more than 6 years in jail with 3 years of supervised release. At first, his conviction was upheld by the conservative U.S. Court of Appeals for the Fifth Circuit. However, the Court of Appeals threw out Rahimi's conviction in a new opinion following the Supreme Court's June 2022 ruling in New York State Rifle and Pistol Association v. Bruin, which overturned New York's handgun licensing program. The court reasoned that even with the restraining order in place, Rahimi was still entitled to exercise his Second Amendment right to bear arms unless, as the Supreme Court clarified in Bruin, the federal government could demonstrate that the prohibition was keeping with the nation's long-standing history of regulating arms. The Court of Appeals determined that the law was unconstitutional since it wasn't. Swiftly after, the Biden administration petitioned the Supreme Court requesting that the justices grant review and overturn the Fifth Circuit's decision. The Fifth Circuit's decision would threaten grave harms for victims of domestic crime, U.S. Solicitor General Elizabeth Prelogar told the justices, emphasizing that governments have long disarmed individuals who pose a threat to the safety of others and that the law falls comfortably within that tradition. Rahimi pleaded with the justices to reject the request for review and uphold the Fifth Circuit's decision. The Court of Appeals' ruling was portrayed by him as a faithful application of Bruin. Nevertheless, he went on. The Supreme Court's ruling in Bruin was only recently rendered, and the lower courts are already hard at work applying the new historical framework and re-evaluating arm restrictions that were previously upheld under the previous, less rigorous standing. Rahimi decided that in light of Bruin, the justices ought to hold off on intervening until after further lower courts have had an opportunity to interpret federal and state gun laws. The judges granted review without remark following 2 sessions in which they deliberated the case. Most likely, the matter will go to trial in the autumn, and a ruling will come at some point in the following year. Finding in Hardin's favor. It seems that the ADF has asked the Supreme Court to examine recent rulings from 6 courts that invalidated the ADF's rule on bump stocks based on the vital information we've gathered. The ADF's final rule on bump stocks was declared entirely unlawful and unconstitutional by the Sixth Circuit in the Hardin versus ADF case. This ruling has been upheld by various courts of appeals who claim the ADF had overreached its jurisdiction by regulating bump stocks as mash guns. The ADF has asked the Supreme Court to sustain its bump stock rule in light of this major setback, stating that it's lawful and compliant with the wording of the statute. But after the negative decision, they made the decision not to request an en banc review in the Sixth Circuit. The idea of Chevron deference, which describes judicial respect to administrative decisions, usually for the provision of an agency, is central to the case. Here, the Lindy rule of validity becomes crucial as opposed to Chevron deference. It says that while interpreting criminal statutes, courts must apply any unclear or ambiguous legislation in the way that benefits the public interest more than an enforcement organization. The panel of the Sixth Circuit Court of Appeals was charged with interpreting the National Arms Act, NFA, to determine whether or not the usage of a bump stock on a certain arm, AR-15s in particular, qualified the bump stock as a mash gun. The court declared that reasonable jurists could come to different conclusions because this was a challenging case to decide. Ultimately, they determined that the ADF's actions related to bump stocks were illegitimate. Given the application of the Lindy rule to criminal matters, it's imperative that we find in Hardin's favor. The Lindy rule prohibits the use of bump stocks as mash guns in this specific situation. As a result, we remand the matter for additional proceedings that are consistent with our decision and reverse the district court's judgment.
While a firearm so equipped would still be regulated by the Gun Control Act,
some legal challenges from both the gun rights community as well as possibly the General Assembly of...
Those are accessories to semi-automatic rifles that increase the rate of fire.
In issuing the pistol brace final rule, did the ATF consider the several years of ATF opinions?
Training order said no. The court has made clear that there has to be a precise law if you're going to restrict the Second Amendment.
Preemptively taking away citizens' God-given rights.
When it comes to gun cases, where is this case leaning so far? How are they leaning?
Uncertainty in bump stock labeling. The National Firearms Act's definition of a mash gun is interpreted differently by each of the 6 circuits, raising the question of whether a bump stock qualifies as a mash gun part. 2 terms that are at the heart of the debate are automatically and a single function of the trigger. The Supreme Court hasn't weighed in on this matter, and the courts of appeals that have considered it have disagreed on the solution. They said that the ADF's own reversal of position, in addition to the numerous conflicting judicial rulings on this matter, serves as an example of the feasibility of different interpretations. The statute is ambiguous because it can be interpreted in multiple reasonable ways. Therefore, in the Hardin case, the 3-judge panel from the 6th Circuit reached a different decision from the prior Cargill panel from the 5th Circuit, which was an en banc court. Though each approached it differently, they finally came to the same conclusion that the bump stock rule is illegal. The 5th Circuit en banc court in the Cargill case concluded that the NFA and GSA's language was extremely explicit and specifically excluded bump stocks as mash guns. Subsequently, the 5th Circuit stated in the same ruling that the rule of lenity, not Chevron deference, should be applied in cases where the phrase is unclear. The Sixth Circuit finally concluded in the Hardin case that the term mash gun lacked clarity, but they thought this ambiguity would lead to a circumstance in which the criminal consequences of the GCA would lead to the application of something akin to the Lindy Rule. They maintained that the Chevron deference was inappropriate.
From adopting new gun restrictions aimed at lowering domestic violence and making gun ownership safer.
Has done their own variation version of it. And so there's a lot of levers and nuance, again, and complexity to making sure that these are done correctly.
Turns law-abiding gun owners into felons is a result of unelected bureaucrats simply enacting a new regulation.
Federal law already bans gun ownership for both felony and misdemeanor abuse convictions, and Ohio,
when attached to a firearm, does not convert that weapon to be fired from the shoulder.
Domestic violence wasn't even an issue really in the founding of our country. People didn't realize that was even a problem.
I want to get a better sense of where the ATF's pistol brace rule derived from.
The ATF is now requesting that the Supreme Court consider this issue in reaction to the ruling made in the Hardin case by the Sixth Circuit. The issue raised in the request to the Supreme Court is whether a bump stock device, as defined by 26 U.S.C. 5845 subsection B, qualifies as a mash gun because it's made and meant to be used in the process of transforming a rifle into a mash gun, that is, a weapon that discharges multiple shots automatically with a single pull of the trigger. According to the ATF, the Sixth Circuit used the lenity rule to declare that bump stock devices are not included in the National Arms Act's definition of a mash gun. Appeals of Cargill and Hardin. In a divided en banc judgment, the Fifth Circuit had earlier determined that bump stocks are not mash guns, and the Sixth Circuit expressly agreed with that ruling. The decision below is flawed for the reasons stated in the government's Cargill writ of certiorari petition. The Sixth Circuit admitted that there has been disagreement among appeals court over whether bump stocks qualify as machine weapons. The FBI, in line with what you would expect, is arguing before the Supreme Court that a semi-auto rifle that has been modified with a bump stock may in fact fire hundreds of rounds per minute with a single stroke of the trigger. As defined by Congress, a rifle fitted with a bump stock is a mash gun, since bump stocks make a weapon that can fire many shots automatically with a single pull of the trigger.
Firing rapidly, almost at the same rate as a machine gun, and that's why these will be banned starting tonight.
Bans any convicted felon from owning a gun. But city leaders say this would allow enforcement by local police officers.
Says a man who was under a restraining order for threatening to shoot his ex-girlfriend.
That's not for us to regulate. If somebody we wrote the rule to make it easy to comply with.
Here's the amount of gun violence that has happened. I think we're reaching a tipping point where we're about to hit desensitization to gun violence.
Small percentage of those guns are ever used in any type of gun violence.
And would not alter the classification of a pistol or other firearm.
All three courts, the District Court, the Merits Panel, and the en banc court, released thorough opinions outlining their individual positions in detail. In contrast, the Sixth Circuit declined to rehash the nuances of this debate here, given the numerous pages of earlier court writings, including the Cargill case, that had already addressed every facet of it. They go on to say that in light of this, the court ought to grant the right of certiorari petition in Cargill, keep the petition pending until Cargill is resolved, and then handle this petition as necessary. In order to support the Supreme Court's review in the Cargill case, which is originating from the Fifth Circuit, the ATF is also utilizing the petition filed in the Hardin case to challenge the ruling of the three-judge panel in the Sixth Circuit. There's a preference among Second Amendment supporters for Cargill to be granted review by the Supreme Court, since many believe he has the best chance of getting one. This is an intriguing scenario, since the ATF is now requesting review in several bump stock cases, but they're also urging the Supreme Court to consider the Cargill case once more in the cert petition for the Hardin case. September marks the start of the next term of the Supreme Court, and Cargill has already been issued for a conference. It is hoped that the Supreme Court will eventually award review in this case as well as the Cargill case, acknowledging that both parties desire review in these cases. ATF faces critical decision. In a significant development, the ATF finds itself at a crossroads following the Vanderstock versus Garland ATF Frames receiver case. the ADF has been pressured to swiftly decide whether to appeal a second two-way or Second Amendment case to the U.S. Supreme Court, and they've confirmed their intent to pursue this course of action. The Fifth Circuit recently rendered its decision on the summary and final judgment of the case. While the panel partially upheld a lower court ruling, it also vacated part of it, deeming that a nationwide vacatur of the entire rule was beyond the lower court's authority. Despite this partial setback, it marked a notable win against the ADF frames receivers rule. Given the decision, the ADF now faces limited options. They can opt to file for an en banc review in the Fifth Circuit or seek review from the Supreme Court. The latter would mean the Supreme Court deliberating on a merit case concerning the ADF frames and receivers rule. Alternatively, the ADF could allow the case to return to the lower court, where the judge may modify the relief, but still result in the ADF frames and receivers rule being struck down. The odds are not in the ADF's favor, considering the recent decisions against them by the Fifth Circuit's en banc panel, which struck down the ADF's bump stock ban. Moreover, the lower court judge has consistently ruled against the ADF in this case. The only recent support the ADF had was an emergency stay from the Supreme Court issued in their favor by a narrow 5-4 margin. The lower court is now seeking clarification from the ADF on their course of action, asking whether they plan to appeal or accept the ruling. Understanding the recent developments in the Fifth Circuit, it's essential to delve into what the three-judge panel stated in their decision. While agreeing with the lower court judge that the rule was invalid, the panel suggested that the vacatur of the rule was overly broad and beyond the relief the judge should have granted. Consequently, the panel upheld the decision but ordered a remand for the more narrowly tailored scope of relief. In essence, despite the nuanced legal proceedings, the recent Fifth Circuit decision remains a significant victory for Second Amendment advocates as it challenges the ADF's frames and receivers rule.
And you should have a right to bear arms in this amazing country that we all live in, but you should be responsible in bearing those arms.
Also, this bill was written with constitutionality in mind, so I definitely had a good feeling.
Laws challenging the way we restrict some people from accessing gun laws.
So some gun laws are okay, just like you have a right to free speech, but you can't just go out and disrupt things.
ATF derives its rulemaking authority in this matter from primarily the National Firearms Act.
City leaders call these two new proposals sensible gun ownership, but they are going to withstand.
Today's decision, which gun safety advocates are declaring a big victory.
This ruling has effectively, and for now at least, killed ATF's pistol brace.
Fifth Circuit rebukes. In a huge defeat to the ADF, the Fifth Circuit emphasized that the agency overstepped its bounds by assuming the role of Congress in terms of arm control as it was crafting its final rule. This was a as it was outlined in the final rule, was not allowed. The decision of the court stated that the final rule issued by the ADF violated the law by exceeding the statutory bounds and going beyond the boundaries that were established by the language that was already in place in the Gun Control Act. Concern was voiced by the court on the possibility that the ADF, through its final rule, could identify behavior as lawful one day and a criminal the next, which would be an outcome that's incompatible with the traditional legal procedures. The criminal liability that was intended to be imposed by the regulation, as described by the administration itself, didn't receive the appropriate input from Congress, which further undermined the law's credibility. Regarding the unlawfulness of two challenged elements or portions of the final rule, the judgment of the district court was upheld and affirmed. Nevertheless, the decision regarding the remedy was vacated and remanded by the court, with the ruling expressly calling into question the countrywide vacatur that was ordered by the lower court. As a result of this legal setback, the ADF has few options available to them. The basic rationale and decision of Judge O'Connor, who frequently ruled against the ADF, have been sustained by the Fifth Circuit.
And I think the justices are clearly poised to uphold this federal law and agree with the Biden administration.
I view this ATF's recent pistol brace rule as a direct assault on veterans.
part that the association and the state's 4 million gun owners are committed to fighting the legislation.
People who are under restraining orders for domestic violence, like you said, from owning a gun.
And I'd ask that you please elaborate on ATF's decision-making process.
Anytime there's a senseless gun tragedy, there's a family left grieving, there's a community picking up pieces.
This is clear despite the fact that they may opt to return to the lower court in order to obtain a relief that is more narrowly limited. As a result of this litigation, the disputed elements of the rule are likely to be knocked down, which is a significant victory for members of the FBC, including 80% arms and maximum defense, as well as other named plaintiffs. A further option is for the ADF to submit a request for en banc review to the Fifth Circuit. On the other hand, considering the recent stance taken by the Fifth Circuit Court of Appeals regarding the ADF's restriction on bump stocks, the agency could be hesitant to pursue this option. As a result of the Supreme Court's decision to grant review in the Cario case, oral arguments are scheduled to take place in February. This provision offers the ADF still another perspective but uncertain avenue of relief. In spite of the fact that neither the en banc panel or the lower court choices look very favorable, the road that lies ahead for the ADF is still difficult. ADF faces a Supreme Court decision. A significant new development has occurred in the ongoing legal battle between Vanderstock and Garland. The ADF is now in a position to pursue a review by the Supreme Court of the United States. A number of recent documents have given light to the proceedings, indicating that Judge O'Connor is conducting an investigation into the objectives of the ADF in the aftermath of the ruling made by the Fifth Circuit. In a recent order, Judge O'Connor instructed the ADF to provide a status report in which they must describe their intentions on whether or not they intend to petition for a writ of certiorari or pursue any other kind of Supreme Court review. The decision of the Fifth Circuit Court of Appeals about the summary and final judgment in the case is the source of the direction issued by the court. A viewpoint that suggests that Judge O'Connor's reconsideration of the case for further relief may be fruitless was adopted by the ADF in its most recent status report with a position. It would appear that the ADF is of the opinion that the most recent emergency stay order issued by the Supreme Court for a vote of 5-4 essentially maintains the status quo until the case is brought back before the Supreme Court. This approach suggests that any prospective changes that could be brought about by the rulings of the lower court or panel would be declared moot until the Supreme Court completes its consideration of the matter. As a result, the order issued by Judge O'Connor seeks clarification on the position taken by the ADF and whether or not they intend to pursue review by the Supreme Court. In accordance with the regulations of the federal government, the ADF has a period of 90 days from the date that the opinion of the Fifth Circuit was issued to submit a petition for review by the Supreme Court. This would be approximately on February 7th. In light of the strategic decision made by the ADF to concentrate on Supreme Court review, it appears that this case will follow a single path.
Now head to full City Council for a vote, probably sometime next Wednesday.
Right, so you have a conservative majority that said the Second Amendment protects this landmark decision.
This rule redefined firearms with stabilizing braces as short-barreled rifles.
There is a slight difference between the Senate version. I support both versions.
Such a firearm would not be subject to the NFA controls.
The Supreme Court has wrapped up its work for this term. It's already looking ahead to the next one.
Now, there has been several injunctions already issued by multiple courts.
Their line of reasoning is predicted on the assumption that any decisions made in the meantime would be overshadowed by the emergency stay issued by the Supreme Court, which is still in place. This increases the chance that the ADF will submit a petition for review to the Supreme Court around the deadline that was established. On the other hand, the dynamics of this case could continue to develop, particularly when taking into consideration the possibility that the ADF will ask the Supreme Court for an extension of time. In addition, there is a possibility that an effort will be made to postpone the case until the conclusion of the Cargill judgment, which is scheduled to be the subject of arguments in February. Due to the fact that it has the potential to affect the precedents in the case of Vanderstock versus Garland, the Cargill case is significant. In essence, the developments in the Vanderstock case carry broader implications for ATF rules and regulations on frames and receivers. While the recent Supreme Court emergency order introduced complexities, the path ahead remains uncertain, contingent on the ATF's decisions and potential judicial maneuvers.
On me, the buyer, yes.
Well, how do I do it?
Well, I think you're going to have to go to a federal firearms dealer.
Nobody can seriously argue that you have to have this kind of a weapon for self-defense.
That's going to do it for this video, guys. See you next time, and bye for now.